And welcome back to Attorneys on Call. In studio with us now, Matthew Bissett, the newest attorney at the Whitley Law Firm, and Ann Oxner, one of the key litigators at the Whitley Law Firm. Thank you both for being here, obviously. And Ann, you do a lot of litigations for the firm. And I know we were talking in the commercial break about some of the trends that you're seeing now in litigation. Kind of tell our viewers what you're seeing and what's going on there.
Yeah, so thinking back about some of the cases I've litigated over this last year, two things that kind of jump out at me. Insurance companies not properly valuing a claim when the at-fault driver was impaired, drunk driving.
So drunk driving, okay.
Correct.
And your client's been injured from this person.
Correct.
Okay.
Yeah, I mean, insurance companies, so why that makes a difference. If you're involved in a motor vehicle accident with somebody who just, is ordinarily negligent, like runs a stop sign and injured, your case, you're entitled to compensatory damages, things like your medical expenses, lost wages, pain and suffering, to make you whole. When someone is impaired, that's aggravated conduct. And so now you're entitled to punitive damages.
Okay.
So that's damages in addition to the compensatory damages.
Okay.
And the point of punitive damages is to punish. What you did was wrong. Don't do that, to make an example out of you for others, just, discourage that conduct from others. So that is, a different level of damages to a case. And so over this last year, I've litigated multiple cases where the at-fault driver was impaired, but the insurance company, before we filed the lawsuit, just completely disregarded that aspect of the case. So we filed a lawsuit, research, develop that aspect of the case, get all the police records, the witness information, the breathalyzer results.
Sure.
And, and then you have to essentially, force the insurance companies to be like, hey, look, if this goes to a jury trial, you know what I mean? You're going to be on the hook for more damages than just the compensatory damages.
So why do you think that is? I mean, I know you can't read the mind of an insurance company or an adjuster, but there's got to be a financial reason for them, which is why they're doing this.
Sure. Well, from where I'm sitting, let's look at what the insurance companies do. Their business model is to take more in premiums than they pay out in claims.
Yeah, exactly.
So they have every incentive to lower or devalue, hold the value of those cases down. And I mean, part of it just seems like, if you want it, you're going to have to come and get it. You know what I'm saying? Like you're going to have to go through the steps. And so that's exactly what we've done.
So in addition to impaired driving, what other trends are you seeing?
Sure. So North Carolina is a contributory negligence state, so I see that pled all of the time.
Explain that a little bit, because that can be a confusing concept for people to understand.
Absolutely. So, okay, let's take a traffic intersection, a traffic collision at a intersection with traffic lights.
Okay.
And it's the classic red light, green light dispute. Somebody ran a red light. Well, even the driver with the green light who enters the intersection on a green light, a green light is not an automatic ticket into the intersection. You still have a duty to look and make sure that it's clear. And so frequently it's that first driver at the intersection who enters on the green light they'll allege that they were contributory negligent, and why that matters. Even if the other driver ran the red light, and like that would be negligence.
Smashed into you.
Correct. If the person on the green should have seen them and avoided that, was also negligent and contributed to the accident, in North Carolina, you can't recover, because that's an old archaic law that we have with really harsh consequences. But again, that gives the insurance company the ability to avoid a claim. And so we see it a lot, even under facts where you think, are you kidding me?
But they're bringing it up.
Correct. That, and then something called sudden medical incapacitation. So how does that, if that were to be an actual, like let's say you're a healthy person and you were driving down the road and you happen to suffer a seizure with zero medical history of that, you would not be held responsible for your damages because that was unforeseeable. Okay. So in order for that to be a defense and to allow the insurance company to avoid the claim, it has to truly be sudden, like no history of that medical problem at all. Well, so I've had 2 cases this last year where that was the defense. And so if that's the defense, now I get to look into your medical records.
Okay.
And in the 2 cases that I've had this year, it was not truly a sudden medical incapacitation, because once you get into litigation and go look into the medical records, there was indication that this was going to be a problem, and it was foreseeable that you were going to have this medical condition while you were on the road and hurt somebody.
Matthew, you've been talking to a lot of new clients. You've been working with them, and you're meeting a lot of these people for the first time when you're going to the hospital, and these people are seriously injured. Tell me about that.
You know, it's a lot of these cases, as Ann's talking about. I will go to the hospital a lot, and I will see these people in a moment of, you know, true fear, and they have so many questions.
Sure.
A lot of the time when it's a catastrophic accident, they don't even know what happened to them. They don't know who was involved in the accident or how they got there, how they were injured. And one thing that we do, we have a great investigation staff. We go very deep into that, and we find out exactly what happened. We find out who's at fault. And people always want to know, how am I going to be compensated for this? Does the other party have insurance coverage? That's something we investigate. And, you know, we also hire the appropriate people, experts, engineers, accident reconstructionists, whoever we need to be able to prove the case and prove what happened to these people that are really scared and need answers to questions.
You mentioned that just briefly. People are saying, does the other driver have insurance? Who's going to pay my? I would think someone ends up in the hospital, they know right then and there, there's a huge bill attached to that. Who's going to pay that bill, right?
You know, and a lot of the time, our clients are Medicaid beneficiaries.
Okay.
And so people will often ask me in the hospital, do I have to pay Medicaid back all the bills that they're paying for me if I ultimately get a settlement from the other person's insurance company? Well, there's a recently reenacted North Carolina law. I won't go into the details, I'll spare you of that, but basically it allows you to go in front of a judge here and ask the judge to treat that person fairly and to lower the amount of money that you have to pay back to Medicaid that they have already paid by way of your medical bills. And sometimes the judge, if you make a good enough legal argument, will actually completely eliminate that amount, and the beneficiary or our client won't have to pay Medicaid back at all.
I mean, that's right then and there, just a perfect example of why someone who's seriously hurt needs to have an attorney, and preferably the Whitley Law Firm representing them.
Absolutely. We don't want people doing this process, you know, in a catastrophic situation without having someone on their side that understands these laws and can navigate the court system for them. I tell people when I see them in these hospitals, let us take care of investigating this and doing all the legal work. You just focus on you and your family and healing, and let us take that burden off of you.
That's great information. Thank you, Matthew, and thank you, Ann. And we're going to be back with more Attorneys on Call in just a moment. Stay right there.